أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله على سيدنا محمد وآله الطيبين الطاهرين السلام عليكم اللهم صل على محمد وآل محمد. Respected brothers and sisters, Assalamu alaikum wa rahmatullahi wa barakatuh. I would like to just remind our online members that they can ask a question by unmuting their mic, and anytime they have questions they are free to ask inshallah and be part of the class discussion. One of the important discussions in determining the recipients of Khums, we know that 50% is called the share of the Sayyids, and they are those who trace their lineage paternally to the family of the Prophet ﷺ. How, according to Islamic law, do we prove that someone is a Sayyid? On page 123 of our book, if you are following with the Arabic texts, the author discusses this very important point in Islamic law. طرق ثبوت النسب. In order to establish lineage, what are the Islamic ways that we can establish that? Sometimes we may not have certainty. If you have certainty that determines your lineage, certainty is always evidence. Today, if someone's father is not known or disputed, and you do DNA testing, that determines beyond any doubt, with full certainty, that this person is your father, your direct biological father, that's a proof. Even if this is not mentioned in any hadith, because back then this method was not available, but since it generates certainty, Assalamu alaikum, yaqeen, confidence, itmi'nan, then scholars will accept that. But historically, in most societies, they did not really have that type of method to establish ancestry. So what are the common ways? The author says, وَلَا يَثْبُتُ النَّسَبُ إِلَّا بِالْبَيِّنَةِ الشَّرْعِيَّةِ. The first method is religious evidence. What do we mean by religious evidence? Whenever you hear bayyina shar'iyya in Islamic law, what is meant by that? Any ideas?
Islamic proof.
What is Islamic proof? Historically, in most societies and villages, what would be proof in court? The testimony of two just witnesses. In court, anytime two adil witnesses who are known to be trustworthy, reliable, not sinful, they're not infallible, but they don't have a life of sin where you can, not trust them or distrust them. You can trust them. They're trustworthy, they're reliable, they're just. Anytime they come to court and they witness that so-and-so person is a Sayyid, we know that he comes from a Sayyid family. And we don't have reason to reject their testimony. We don't have any reason to reject them, right? We don't have any conflicting evidence. That in itself is called bayyina shar'iyya, and in an Islamic court system or legal system, it's accepted. Historically, this was the most reliable way to determine subjects and rulings. Because in the absence of forensic science, a lot of things had to be determined by trustworthy people. So if these people were known in their community to be reliable, to be trustworthy, they have a history of being just and pious, their testimony in court would be accepted. Even grave crimes like acts of murder. If two people come and they testify in court that X person is the killer, we saw that person with our own eyes, and of course we don't have conflicting evidence, right? That flies in an Islamic court. And it was the most practical system. Yes, Islam did put conditions for certain types of offenses. For example, with adultery, 2 is not enough. You need 4 just witnesses who saw the actual act. So, bayyina shar'iyya, whenever you hear that, it means 2 just witnesses. Unless Islam specified that 2 is not enough, you need more. So that's one way. If we have 2 just, pious people, they come and say, X person comes from the Bani Hashim, comes from the Sayyid family, his father is a Sayyid, paternally he can trace his lineage back to the Prophet. This person becomes eligible to receive Khums. That's one method. Any questions about this method? Yes.
Do we still have this method? Is this like applicable today?
In most Islamic countries, yes, it's still applicable. If you go to court, or let's say you go to a marja's office, and two just witnesses come and say, this person is Sayyid, we testify. And we don't have conflicting evidence, right? Sometimes you have clues that could disqualify that testimony. But if it's a neutral case, then yes. Even until now, the office of the Maraji', they will accept that. In an Islamic country, in the court, they will also accept that.
I know in Iran, they add the word Sayyid.
Yes. So in Iran, in your ID, your national ID, they call it over there. There is kind of a law that you would put the word Sayyid before your name to identify who's a Sayyid. And if it's a female, either Sayyida, Fatima, or Fatima Sadat, as they call it over there. But not for every single family that was the case. Because when they started this whole new system, some families maybe did not go and submit evidence. So if someone does have the Sayyid, it gives certainty to the office of the Maraji' that this person is a Sayyid. But if someone doesn't have it, that's not evidence that they're not. Maybe they were not part of the records when they were making them. But yes, that is one way that could generate certainty and proof. Still, some strict Maraji' may not accept that. They're like, okay, that's a clue, but that doesn't give me certainty. I don't know who in court put that. Maybe you bribed somebody and they put that title for you. I don't know, just as an example. So they'll still demand other evidence, such as two witnesses. The second way to establish that, to establish any ancestry, not just someone who's a Sayyid, any ancestry, this person is this person's father, أو حكم الحاكم, whenever the ruler, what do we mean by ruler in Islamic law? Jurist. Hakim is shar'i, the religious jurist, whether it's a marja' or a mujtahid, a qualified jurist. If they issue a ruling that based on the evidence that I've seen, this person is a Sayyid, he comes from a Sayyid family, this person becomes eligible for Khums. So in Islamic law, hukm al-hakim is also applicable and it's acceptable. Number 3, أو الشياع الموجب للإطمئنان. You will find this in a number of areas in Islamic law where this actually will generate a ruling for us. What's al-shiya' al-mufid lil-itmi'nan? Something that is so widespread, so commonly known, that it generates confidence this is the case. There are some families in the Middle East, whether in Iran or Iraq or Syria or Lebanon, they may not have an actual family tree that you can go and historically verify with evidence. They may not have that. But this family is known in their society to be a Sayyid family, such that it generates confidence that you can assume them to be Sayyids. In Islamic law, this is acceptable. So we do have in the seminaries in Najaf and Karbala and Qom and Mashhad families that have been historically known to be Sayyids. Now if you demand them evidence, they probably cannot produce evidence. Like, what kind of evidence do you want me to give you? Now for instance, with my family, I do have a family tree. But a lot of Sayyids may not have a family tree that is certified and verified, and you can go 40 generations back to the Prophet with evidence. A lot of Sayyids, most Sayyids probably cannot produce that for you. But how do we treat them as Sayyids? Because from one generation to the other generation, they were known and accepted to be Sayyids. This was so well known that it generates confidence, they are Sayyids. If it generates such confidence, then ancestry is established and they are eligible for the Khums. So this is the third method that we can establish ancestry. Any questions on that? Or any objections to that?
I think the third one is similar to the second one, right? Or am I just lost?
No, the second one is the Hakim al-Shar'i, the jurist. For whatever evidence he sees, he says, I issue a statement or a ruling that this family is Sayyid.
And the third,
In Islamic law, that's acceptable. The third one, we don't have a jurist issuing such a statement. It's just well known. For example, you go to Iraq and you ask the Hakim family, who says they're Sayyid? Well, everybody says they're Sayyid. Well, what's the evidence? We may not have evidence. They'll tell you, look, my grandfather's generation and his grandfather's generation, they knew this family to be Sayyids. So we can safely assume it generates confidence that they were Sayyid. Because remember, in the past, people did not keep records. And a lot of times with Sayyids, they went through eras of persecution where they tried to keep that low profile too. And so maybe some families initially knew, and then later on, as the situation, the security situation would improve, more and more people would know about that. But as long as in that society, it's so well known that this family is a Sayyid family, in Islamic law, that's good if it generates confidence. Yes, if it doesn't generate confidence, there's reason for you to doubt this widespread understanding that this family is a Sayyid, for whatever reason, then that's fine. I know, for example, in Jordan and Hijaz historically, there were some families who were not even followers of Ahlul Bayt. Sometimes, in order to gain prestige that they're from the Hashimi family, if they had political power, they could make up the idea that they're Sayyids and order the judges to accept that. And then over time, this becomes well known, okay, that they're a Sayyid family. But you have reason to doubt that. It doesn't give you confidence because there's something behind it. In that case, it's not applicable in Islamic law. So the author doesn't say any type of widespread understanding will make a person Sayyid according to Islamic law. It should also generate confidence. You don't have reason to doubt it. There is no counter evidence. So these are basically the three types of ways that through which we can establish ancestry. Yes?
so for the first and second methods, are they required to have documents?
They're not required to have documents. The just witnesses can go and they will testify in court. Yes, the judge can ask them, on what basis are you making this testimony? They could say, we heard this from our fathers and grandfathers, and we always had certainty about that. And we are testifying that they are based on the confidence that we have. That's fine. You don't need to produce any physical document.
And there are a lot of people who are known to have knowledge in genealogy.
Absolutely. There are scholars of genealogy. They're also usually consulted as well. And if there are two witnesses who testify something, then a scholar of genealogy comes and says, I don't want to accuse them of lying, but they're mistaken, because I have evidence or confidence that that is not the case. And they could produce the evidence. See, now you have conflicting reports. Now we have a way, on how to deal with that. But these two witnesses, if there's nothing that is conflicting with their testimony, it's accepted in an Islamic court. By the way, today, one of the challenges that we have in the Middle East is sometimes you see an entire tribe or family suddenly becoming Sayyids. And they tell you that, we've investigated documents and we discovered that our ex-grandfather was a Sayyid. It was not well known back then, but now it's well known. Maraja are split on that. A number of them have their reservations and they don't accept that. For them, it does not generate confidence. Some of them do. So it's a controversial issue in the Middle East. It happens once in a while. Once in eastern Hijaz, Saudi Arabia, an entire family, basically, there was also a split in that family, but many members of that family declared themselves Sayyids. And scholars from Qom and Najaf had to weigh in. Some of them were scholars of genealogy. They doubted it. It was a big, big controversy. So that sometimes does happen. And you'll have different jurisprudential opinions about it. The author says there's also one method some people have claimed, but it's not applicable. Those people, some people say, well, whoever claims to be a Sayyid, treat them as a Sayyid unless you have evidence that they're not. Whoever says, I'm a Sayyid, khalas. Why do they say that? Because we have a law, a principle, asalat al-sahha, right? Asalat al-sahha in Islamic law says any Muslim who's doing something, any act, you assume that act to be correct. Let me give you some examples. Let's say you go to someone's house, the carpet was najis. Either kids made it najis or whatever, something made it najis. The owner of the house tells you, I purified it. Taharta. Do you accept their claim, or you have to investigate and tell him, show me proof that you purified it correctly? You accept. Why do you accept? Do you have ilm? You don't have knowledge. You're not sure if the person really purified it the Islamic way. Asalat sahhat amal al-Muslim. We have a law that says any Muslim who says, I did something, I slaughtered the animal according to Islamic law, I purified this, I did my prayer, I did my hajj, whatever it is, any Muslim who makes that claim, and we don't have evidence, counter evidence, we accept this claim. This is an Islamic law. Some people try to apply it here. This person saying, I'm Sayyid, assume he's correct. The author says, no, this doesn't fly here. Why? He says this law, which assumes your actions to be correct, the benefit of it is that we cannot accuse this person of lying. So we cannot punish him in court or penalize him for lying. We can say, okay, maybe you have proof that you're a Sayyid, that's fine. We're not going to accuse you of lying, because we assume you as a Muslim not to lie, unless we have evidence, of course. And we won't punish you for that. However, the khums is an obligation that we must give to a Sayyid. You claiming that just does not give us such certainty. And when we give khums, we need to give it to someone whom we're certain or confident he is a Sayyid. So because we have an obligation here, a financial obligation, to relieve ourselves from this financial obligation, we need to know that you're a Sayyid. So your claim is not enough. Bring witnesses, bring evidence. Yes, with your own acts, your own ibadah, for instance, what you purify and don't purify, we accept. But now I have a financial obligation. Islam tells me, give this khums to its recipients. I need to know that you're a recipient. It's not enough for you just to claim it. Because now I have an obligation. So you see the difference here, right? So scholars have not accepted that if a person comes and makes a claim without evidence, it's not accepted. Yeah, we don't accuse him of lying. I will not tell him you're a liar and I'm going to put consequences for that. No, you could be truthful, but that's not evidence for me.
So we can give our khums to only the Sahm al-Imam, right? To any Sayyid?
No, we'll talk about it right now. So on the next page, after establishing this issue of ancestry, the author on page 124 talks about Sahm al-Imam and Sahm al-Sada. When the Imam was present, in the presence of the Imams of Ahlul Bayt, we see the history of the Imams, the practice of the Imams, and the hadiths indicating the Imam himself would spend the khums as he would see fit. The 3 shares, the Sahm al-Imam, God's share, the Prophet's share, the Imam's share, and the other 3 Sayyid shares, for the yatim, the orphan, the miskin, the poor, and Ibn Sabil, the wayfarer. The Imam alayhi salam, it was his responsibility to dispense the khums. He would do as he wished, as he saw fit. Or he would appoint wakils, representatives, to do that on his behalf. So when the Imam's present, we don't question, well, on what basis are you giving the khums? How much are you giving? Which share? Half of it, Sahm al-Imam, half of it, Sahm al-Imam. The Imam decides. He can give it all of it to the Sada. He can do whatever he wants with it. Because he has that authority from Allah subhanahu wa ta'ala to spend the khums as he wishes and as he sees fit. In fact, the Imam alayhi salam, in certain periods, when the persecution intensified on the Shia, there was a year or two where the Imam relinquished the Shia from paying khums. The Imam says, this year nobody has to pay khums. Because the Abbasids are monitoring us, and they're monitoring this financial activity. If you pay khums, you can get in trouble. So the Imam just lifted the khums altogether. He has the right. The Imam could do whatever he wants with khums. He's authorized by God. So no discussion about his presence. The discussion is zaman al-ghayba, during the absence of the Imam. Then what happens with the khums? This is a somewhat controversial issue because scholars have different opinions here. And the evidence that they cite may not be so convincing to some, even to some scholars, right? So now let's break it down. Sahm al-Sada, Sahm al-Imam. The Sayyid's share, which is the 50% of the khums, that goes to the yatim, the orphan, or the poor, or the wayfarer, the majority of scholars historically have said you can directly give it to the Sayyid without needing permission from your marja. Because they are the recipients of khums. So if you know a Sayyid family that deserves the khums, you can directly give them the khums. Question. 50% of the khums, exactly. The 3 shares, which are 50%. So if your khums is $1,000, $500, you don't need to go to any marja's office, any permission. You directly give it to the Sayyids. Most scholars have said that. Question. Why is it that in the Risala Amaliyya, the book of rulings, of the many maraja' today, they will tell you no, as an obligatory precaution, even Sahm al-Sada, either bring it to our office or get permission from us to give it. Question, why? What's their evidence that you have to take Sahm al-Sada and be authorized by the marja' to give it to the family? Why can't I give it to any Sayyid family directly? Why do I need my marja''s permission?
Because they know who's the correct Sayyid. And based on their...
Yes, so that's the argument. See, we don't have any evidence in hadith that you have to give Sahm al-Sada to the faqih, to the religious hakim. We don't have such evidence. There is no such evidence. In Islamic law, any hadith that says you have to get the permission of the hakim. So where are these maraja' getting this ruling from? The argument is as follows. The marja' is the one who best knows which families are probably Sayyid or not. Number 2, whether they deserve the khums or not. Because there are conditions for khums, we'll examine them. One of them, the recipient of khums must be a believer. If someone's a Sayyid, right, but they're not a follower of Ahlul Bayt, or they're a kafir, an atheist, or whatever it is, like Abu Lahab, they don't deserve the khums. The khums does not go to them. Even there are scholarly opinions, Tariq as-Salah, the one who does not pray, is that person a recipient of khums or not? Many scholars say no. Now who better knows these circumstances? Since the marja' says, based on my experience, I know this better than others, get permission from me before you directly give it to Sayyid family. That's the argument. Now is that a convincing argument or not? Scholars have different opinions. But there is no evidence in hadith that you have to give it to your marja' or you get permission, ijazah from your marja'. The original law states you give it to the Sayyid. As long as you believe they're qualified, you give it to them. You don't need any permission from anyone. But the reason why some of these maraja' are saying as an obligatory precaution, bring it to us, they just want to make sure that it goes to its rightful place. So just know the background behind that.
During the Imam's time, do we know if people did used to give it directly to Sayyids, or it went straight to the Imam and then the Imam?
It's not really clearly known to us. Because the khums issue was a sensitive issue with respect to the Abbasid governments, not many details about it are disclosed, how the Imams dispensed it or what exactly they did. But remember, when the Imam is present, when he's present, the Imam ﷺ is from the Ahlul Bayt, right? So he represents all Sayyids. When he is present, you give it to him. It's clear why you need his permission. The question is, in the absence of the Imam, why do you need the permission of the scholar? The scholar, he is not representing all Sayyids, according to hadith. So why do you need his permission? That's the argument. But when the Imam's present, yes, he can demand that bring all the khums to me. I decide what happens to it. The Imam has that right. But what about the scholar? And then of course we have the issue of wilayat al-faqih and how much authority the scholar has. That's a different discussion.
No, I'm saying the scholar is one of the Sayyid.
He's one of the Sayyids, exactly. If he's a Sayyid. You can follow a marja' who's a sheikh, who's not necessarily a Sayyid. So he doesn't represent all Sayyids. So why do you have to give it to him? That's the argument, yes.
I could say there is a case for, say, like Sayyid Sistani, for example. In the case of so many conflicts in Iraq, for example, when you give, when the Shias essentially give the Khums, the office gets more prominence. And so therefore, when he directs it back to the people, in the society, he has wide sort of impact. Even
It has greater impact.
on what things they should and should not do. Otherwise, when you don't do that, a marja is just another person somewhere, he's sitting in.
But see, the argument of some people is that if this share is to the poor Sayyids, why can't I just give it directly? I know a poor Sayyid here or in Pakistan or somewhere else. Why can't I just give it to them directly? Why do I need to go through layers and channels of representatives and marjas for me just to do that? That's kind of the argument here, right? Yes, we understand the institution of the marja'iyah and the impact that it has, but we're just trying to see technically, legally, what's the basis for it. So there is no evidence from hadith that binds you to give that to the marja' or even seek the permission of the marja'. But the reason why a number of maraja' have stipulated that condition is because they know better who deserves the khums, which family is really sayyid, and whether they're qualified or not. That's the argument.
What's the brothers? It also has a negative impact because most of my Sunni friends were saying when ex-Marja died in Iraq or Iraq, he left over $1 billion because he was so rich, taking all his people's money. No, seriously, that's the impression and the Sunni, like those Marjas taking all people's money.
First of all, there are exaggerations in these reports, definitely. But you remember, sometimes the marja' also recognizes that after him, there's another marja'. So there may be some amount of money to guarantee the immediate future, the next year, the next 2-3 years for the hawza. Now, sometimes mismanagement could happen. The marja' dies, someone comes and may somehow mishandle some of the funds. But usually it's expected that it's transferred to the next marja'. Or at least the next marja' authorizes what happens to it. So if an institution owns that money, it needs permission from the next marja' to spend it appropriately. So there are definitely exaggerations. Yes, there is some mishandling. Remember, people are not infallible. Those who surround the marja' or family members, they're not infallible. Sometimes mishandling does happen. It happened during the times of the imams, by the way. The wakils, the representatives, the imams would appoint. Sometimes it would be the case, if they found the opportunity, they would mishandle the funds. In fact, the whole Waqifiyya school of thought started because of this. Ali ibn Abi Hamza al-Bata'ini was one of the top representatives of Al-Imam al-Kadhim alayhi salam. When the Imam was imprisoned for years and years, Ali ibn Abi Hamza al-Bata'ini was saving the khums money and the religious dues in his house or somewhere, so that when the Imam comes out, he'll give it to him. Well, Al-Imam al-Kadhim alayhi salam is martyred in the prison. Ali ibn Abi Hamza al-Bata'ini and some others realized they have massive wealth in their house and their homes. So they had two options. Recognize that Imam al-Ridha is the next Imam, which meant that they had to submit the funds to Imam al-Ridha, or spend it as he directs them. Well, their nafs, their satanic nafs, did not accept that option. The next option was, reject that there is another Imam. Reject the Imam of Al-Imam al-Ridha and say, Al-Imam al-Kadhim alayhi salam was the last Imam, and in fact he's the Qa'im, he disappeared, and we're saving the money, inshallah, when he reappears we'll give it to him. And they took that money for themselves. They started an entire sect called the Waqifiyya. They rejected the Imam of Imam al-Ridha alayhi salam. It started because of money. Not because they had an issue with the belief system. No, they knew everything. This happened during the times of the Imams. And Imam al-Ridha alayhi salam cursed them for that. In fact, when Ali ibn Abi Hamza died, Al-Fadl ibn Sha'dan narrates this. He's one of the close companions of Al-Imam al-Ridha. Al-Imam al-Ridha said, right now, when Ali ibn Abi Hamza died, right now when the angels put him in his grave, they asked him about the Imams. He stopped at my father. He couldn't admit I'm the Imam because the angels would tell him, okay, you rejected Al-Imam al-Rida and you mishandled the funds. Al-Imam al-Rida says because of that, they struck him, the angels right now, struck him with this lash made from flames. His qabr, his grave, caught on fire in the barzakh until the day of judgment he's burning. A hadith from Al-Fadl ibn Shadhan. So see, even some of these wakils, they betrayed the Imams of Ahlul Bayt when it came to these funds. But still, the Imams alayhim salam, did you see them cancelling this whole system of wakala? No. Al-Imam al-Rida had wakils, Al-Imam al-Askari had wakils. Remember, life is a test. Sometimes things can happen. If someone does something wrong, it doesn't mean the system is invalid. Yes, they should do. The scholars should go out of their way to make sure they're dealing with trustworthy people. But sometimes there are slips here and there.
This guy has an opportunity of shafa'ah on the day of judgment.
We can never rule out shafa'ah, but the one, he displayed enmity towards Imam al-Rida. See the hadith from the Prophet. Who?
No, I said he deserved to go to hell.
Yes. You mean Ali ibn Abi Hamza al-Bata'ini? See, because he displayed enmity towards the Imam, we have hadiths that the one who has enmity towards the Ahlul Bayt is disqualified from shafa'ah. So it's tough, but again, Allah reserves the right to forgive whomever He wishes. But it's tough, that's all I can say. He is disqualified. He doesn't deserve shafa'ah. Now, if Allah wants to out of His favor, that's fine. But he doesn't deserve shafa'ah. So, half of the khums is given directly to the sayyids. Most scholars historically have said you don't need permission, you can just give it to them. Now, who are those sayyids who are recipients of the khums? Basically, the author says, أهل الحاجة الذي لا يملك مؤونة سنته. Who's the faqir, the sayyid who's poor? If you remember in the book of Zakat, we talked about who's poor according to Islamic law. Anyone who does not own ma'unat as-sana. What's ma'unat as-sana?
Salary?
Not salary.
Wage?
Exactly, the expenses that you need to go by for you and your family. If the person struggles to meet, what do they say? To make ends meet, if they struggle with that during the year, then they are qualified to receive khums. So it doesn't have to be somebody who's homeless, somebody who doesn't have a house, somebody who's starving. No, these are extreme cases of poverty. But poverty in Islamic law is anyone who struggles to make ends meet. They deserve zakat, they deserve khums.
What if they're not sayyids? You know they're for sure they're qualified.
You cannot give them from Sahm al-Sada. We can give them, zakat, sadaqat. Sahm al-Imam, we can give them by the permission of the marja'. We'll talk about that. Yeah, it needs permission from the marja'. So that's the miskeen. What about the yatim, the orphan? An orphan who comes from the family of the Prophet ﷺ is a recipient of the khums. Ibn as-Sabil. Today with credit cards and cash and banks, it's no longer really applicable. But back then you could travel and trips would take months. Sometimes you run out of money. Or there are looters on the way, they would loot you and your caravan. So you go to a village, you're rich in your country maybe, you're fine. But now you're a poor person, you don't have any money. Khums is given to them as well. If they're sayyids, khums is given to them. Just like zakat would be given to the non-sayyids. So now we've discussed Sahm al-Sada, and we mentioned that there is no evidence that it must be given to the marja'. And we mentioned why some maraja' have stipulated that condition. Question, if you have a relative that you must spend money on, can you give them from your khums? An example is, your wife is a sayyida, let's say. Can you give her from khums?
No, those are responsibilities.
Exactly. If you have a financial obligation to take care of the expenses of someone, whether it's son or daughter, wife or parent, you cannot give them from khums and zakat. You have to give them from your own money. So let's say your wife the shelter that she needs, the clothing that she needs, her basic expenses that she needs, that cannot be given to her from khums money. Because you, the husband, you're obligated to provide for that. So on what basis are you giving from khums? Regardless of khums, you have to guarantee that for her. So it's not possible to give her the khums.
What if it's my aunt or uncle?
Aunts and uncles, because you're not required by Islamic law to spend on them, they're not wajibi an-nafaqa, you can. Cousins. But we have the parents and the children and the spouse, it's wajib to spend on them. So you cannot give them from your khums. Yes, there's a discussion. The very basic necessities for your wife you give her, right? But she still could use maybe some more money for some expenses that it's not wajib for you to guarantee, but she still deserves it according to society. Then you can give her from that khums. Because that additional amount is not wajib for you to guarantee.
So if she want iPhone 11, like
Well,
fancy car.
see, if one day society considers having a smartphone as a necessity, right? If it does consider it as a necessity, then yes, one would have to guarantee that. Yes, not a fancy phone, but the very minimum would count, yeah. Now let's talk about the other half, which we call Sahm al-Imam. Sahm al-Imam. During the time of the Imam, he does with it whatever he sees fit. In Zaman al-Ghayba, what should scholars do with Sahm al-Imam? There is no clear scholarly opinion about this. In fact, we have some scholars like Sahib al-Hada'iq. Sahib al-Hada'iq was one of the great scholars of the past. He kind of did have an akhbari school of thought. He says, I examined the scholarly opinions about Sahm al-Imam during the Ghayba. I found scholars have 14 opinions. What you do with Sahm al-Imam. Now, why do we have so many opinions? Because from the hadith, it's not very clear what should be done with Sahm al-Imam. When the Imam was present, he would spend it accordingly. But when he's absent, what exactly is supposed to be done with Sahm al-Imam? It's not that clear. In fact, there were some scholars, they were the very minority, by the way. They would bury the khums. They would take the money of the khums, they would bury it, and they would say, this belongs to the Imam, to the Mahdi. Whenever he reappears, and inshallah it's soon, let him deal with it. This is a rare opinion, but I'm just showing you the diverse range of opinions that we have. Some scholars, centuries ago, did believe in that, especially some akhbaris. They're like, that's not my money. Now you could tell them, but how would the Imam spend it? It's like, I don't know how the Imam would spend it. I'm not sitting in the position of the Imam. I don't know how to spend the khums. Let him take care of it whenever he reappears. Yes, some of them would actually do that. It's very rare, like I said. And you could argue this is a waste of resources. There are poor people and you're burying this money. Yes, there are problems with this view. But I just want you to understand that there's a range of opinions. And by the way, those scholars, they had a point for themselves. They're like, that money is not mine. It belongs to the Imam, to the Mahdi. Yes, I represent the Imam in religious rulings by giving you religious rulings. But how the Imam himself he'd spend it, how do I know that? I'm not going to take that responsibility. So bury it. The other scholars said, look, by burying it, you did use it. You're withholding it from potential projects. That is a type of using it. And in fact, it's the worst type because you're absolutely wasting it. So that opinion did not really survive in history.
When you build a masjid, isn't it a house of God?
Yes.
So can't you use that?
We'll talk about that.
Okay.
We'll discuss that, where it's spent. So there are 14 opinions. What exactly happens with Sahm al-Imam? Who do you give it to? Some scholarly opinion was give it to the Sayyids. If there are poor Sayyids, give it to the Sayyids. There is a hadith that says if the Sayyid's share of khums is not enough to cover the Sayyid poor families, give from Sahm al-Imam. That's an opinion. The most popular opinion is that the faqih, the jurist, uses the Khums money in order to satisfy Imam al-Mahdi in projects that he's confident يحرز به رضا الإمام المهدي, such that he knows the Imam would authorize that. The Imam ﷺ would accept that. So now scholars have the following priorities. They say the most important priority, as we know from the life of Ahlul Bayt, is what? Deen, religion. Anything that protects religion, takes religious values and teachings to the next generation. Seminaries, religious schools, we know that's a priority that the Imams of Ahlul Bayt would definitely authorize. Because in their lifetime they would spend on these types of projects. In their lifetime the Imams of Ahlul Bayt gave high priority to ilm and fiqh, spreading the knowledge of Ahlul Bayt, peace be upon them. So any project and institution that spreads the knowledge of Ahlul Bayt, the marja' will tell you, I have confidence this is approved by the Imam of our time. And that's why a lot of the khums is spent where? On seminaries, on hawza institutions. The tens of thousands of students who are studying, the schools that they built, the research projects that they fund, the books that they publish. These are large-scale operations. And they fund it, through khums, because their argument is, we are confident that this satisfies the Imam alayhi salam. That's one priority. Another priority that we see from the lives of Ahlul Bayt are poor families from the mu'mineen, from the believers, from the followers of Ahlul Bayt. We know that the Imams would give them money. And hence, a part of Sahm al-Imam is given to any poor family that's qualified, that's mu'min. And when we say mu'min, it doesn't mean they pray Salat al-Layl and they're the highest levels of Iman. No. A mu'min is someone who's decent and a follower of Ahlul Bayt. A follower of Ahlul Bayt. They are recipients of Sahm al-Imam. And the Imam alayhi salam can, the marja' can authorize that. Another example is what you mentioned. See, we examined anything that strengthens religion. A masjid, a community center, where people come, learn, supplicate, pray. That is an area where most maraja' will say yes, that's eligible for khums. And that's why most centers around the world, Husayniyas, institutions, they have ijazah from the marja' to collect part of the khums. Hospitals, humanitarian projects, orphanages, many of them are authorized by the marja', because the marja' tells you, I have confidence that these humanitarian projects, they satisfy the Imam of my time. And he does authorize such projects. They have confidence. Now, here's the fundamental point. And this is an area of scholarly debate. Can you use Sahm al-Imam directly and give it to an area where you are confident will satisfy the Imam of your time? Or you need to give it to your marja', or get permission from your marja' to spend it, or give it to a project that he's already authorized. He's already given his permission for. Do we have evidence in Islamic law that you have to give the khums to the marja'? Sahm al-Sada, we talked about it. What about Sahm al-Imam? Is there evidence, clear evidence from hadith?
I'm assuming no.
There is no clear evidence from hadith. So why is it that the maraja' tell you, well, you need to bring it to our office, or at least give it to an authorized project. You can't just give it to whatever you want directly. That will not release you from the burden of khums. There are a few arguments. One argument is there is a hadith, which is a hadith by Ali ibn Mahziyar, one of the companions of Imam al-Jawad and later Imams. In this hadith, I'll share with you the text of this hadith. So Al-Imam al-Jawad alayhi salam, he gives a command to the Shia. He says, فَمَنْ كَانَ عِنْدَهُ شَيْءٌ مِّن ذَلِكَ. Whoever has these financial dues that they must pay, such as khums, فَلْيُوصِلْهُ إِلَى وَكِيلِي. Let him give this khums to my wakil, my representative. Let's examine this statement here. Scholars have two opinions about this statement. One group of scholars, they say when the Imam is giving us an instruction here, give the khums to my representative, this applies in all eras. During the ghaibah, who represents the Imam? according to the hadiths that speak about the role of the jurist in representing the imams and the authority that a hakim, that a faqih has. Well, and in the time of ghaibah, the maraji', they represent the imams. And the imam says, give this money to my wakil. They are the wakil of the maraji', so give it to them. Or at least, if you spend it, make sure you're authorized by them. That's the first argument that scholars have made. Have all scholars accepted this? No. Why? What would be a counter argument? The hadith is sahih, we accept it. Imam al-Jawad says, give it to my wakil. No doubt about that. But what are some counter arguments?
That was only made at his time.
Be a little bit more specific. Okay, it was made at his time.
It's been 1400 years, so we don't really have, or 1200 years, we don't really have any true representative.
You have the idea.
Because the Imam was the one who basically monitored.
Directly appointed them and monitored them. Yes. So here's the idea. See, in this hadith of Imam al-Jawad alayhi salam, Imam al-Jawad had specifically appointed a wakil. And he said, give it to my wakil, Ali ibn Mazyar, for example, or someone else. Assalamu alaikum. Whereas the maraji', they are not specific wakils of the imams where the imams directly appointed them. They are general representatives. And there's a difference between a specific wakil representative and a general representative. The hadith is about a specific wakil that the imam directly appointed by name. Right? So there's a difference here. Yes, we accept maraji' do have some level of representation from the imam, but not like these specific wakils. So there's a difference. Number two, who said the maraji' are representatives of the imams in financial matters? We know that they are representatives in religious rulings. Yes, we have evidence for that. In taqleed, we talk about that in detail. But what about financial obligations? Who says? Scholars are split on this issue. Have you heard of walayat al-faqih? The authority of the jurist? How much authority does a jurist have? Historically, most scholars have said, what we understand from hadith is that the scholars have this much authority. They issue rulings, and in certain cases where there is no wali, guardian, they are guardians. You have an orphan who's lost in the street, we don't even know who the guardians are. No grandfather, no father, nobody. Who is the guardian of that orphan? The marja', al-hakim al-shar'i. He is their guardian, as an example. There's a masjid that is a waqf. It's a religious endowment. You know that waqfs have guardians. They oversee them. Let's say there's a masjid, nobody is the guardian of it. The guardian died, nobody after him was designated to be the guardian. Who becomes the guardian of that mosque, for instance? The marja', the hakim al-shar'i, the jurist. As for collecting khums, where do we have in the hadith that the marja' is authorized to specifically collect the khums? This is the argument of a number of scholars. They're like, so yes, the marja' does represent the imam in certain limits, but not in everything. The other group of scholars, they say, no, we have our evidence that the marja' has this general authority and he represents the imam in a more general term. So this issue is discussed in walayat al-faqih. How much wilaya authority does the faqih have? Does the jurist have? Depending on what the scholar believes about walayat al-faqih, they'll tell you whether you have to give the khums to the marja', be authorized or not. That's the second argument. The last argument before we break for salah. Okay, fine. The current maraji', they're saying, we don't have any specific evidence from hadith that we are to collect the khums. However, who knows better what satisfies the imam of your time? Someone who studied for 50 years, he knows the system of imams, the history of the imams, he knows what religion needs today, right? What our religious sciences, what they need. Who is able to make a judgment that's more in line with Ahlul Bayt? The layperson? Or a marja' who's closer to the teachings of Ahlul Bayt, not because he's a better person, but he's more of an expert in that field. So the marja' says, I am better equipped to make that designation and to make that judgment. Yes, I'll research. Theoretically, you should have people helping you also determine which projects are more important than others. But the marja says the average layperson may not be qualified to make that judgment. So when you as a layperson directly give your khums, are you sure you relieved yourself from the obligation of khums and you gave it to its rightful recipients? Maybe, maybe not. You don't have certainty that you released yourself from the khums. But the marja who's an expert, and he is closer to the system of Ahlul Bayt, he may have that confidence, or he is closer to developing that confidence. So that's why you should give it to your marja, or at least something that's authorized by the marja. Because the marja sees angles you may not see. He's more familiar with the imams and their path and their ways and the decisions the imam made. So that's the argument there. What do you say? Very briefly before we go for salah. What's your take on this? Which do you lean towards? Of course, I'm not asking you to issue fatwas. Maraja are qualified, but based on the academic discussion, what would you say rationally? Like if you want to rationally and without any biases, give your opinion here. What would you
I
say?
think it makes sense because
It makes sense to what?
to let them make the decision because they're able to prioritize and see from their perspective.
They're better able to prioritize and see from their perspective. Any other thoughts?
I agree, give it to the experts.
Give it to the experts.
I have a question on the way Fakir, but I'll ask this next time.
We'll discuss that inshallah. وصلى الله على سيدنا محمد وآله الطاهرين. اللهم صل على محمد. السلام عليكم.